we have, or that the first accused person has opposed this application is that if you look at the grounds comprehensively, what the accused persons, 3 and 4, the applicants are trying to do, they are actually re-arguing the postponement application. The judgment is delivered, postponement is not granted, reasons are advanced in that judgment that I'm not granting you a postponement because of this and this and this, and then a recusal application is brought challenging what the court has decided in that judgment. So we submit that it is actually a re-arguing, it's an attempt to re-argue the postponement application which has failed. That is not what the purpose of recusal applications are, and that amounts, my lady, to an abuse of process if properly viewed against the context of what is contained in the affidavits. What the applicants have failed to do on the papers, and that excludes the statements that are made today around the publication by the judiciary as to whether or not there is civil experience in our magistracy, those issues are not pleaded, they are not on the papers. The applicant must make out their case on their papers. And there they have failed to demonstrate how a finding by this court that the previous application were without merits and that there is a tactical delaying strategy at play. My lady, we need to look at what the court really said, because it seems that it was being taken out of context. Properly viewed, this is what the court said about the allegation that is being made. I believe you would find that in paragraph yes, you find that you started in your judgment at paragraph 108, and this is what was stated, my lady. The court said application after application has been brought before the court tasked with the hearing of the case. None of the applications brought before the criminal court have been found to have any merit, and it is difficult to find when looking at the numerous civil applications that have simultaneously been filed, decided and appealed against, as well as the applications which are still pending, that there is not, it is difficult to find that there is not, at least to a degree, a tactical delaying strategy at play from the side of the specifically accused 2 and 3, accused 2, 3, and 6. So what the applicants are saying, that comment, that it's difficult to find that there's it's difficult not to find that there's a delaying strategy at play. That comment is what will stop this court from determining whether the accused persons are guilty or not when the evidence is brought. Meaning when the state brings the witnesses, documents are submitted, because of that comment, the court will not be able to bring to bear an impartial mind. And we submit that that is really, even if you stretch it, my lady, there is just no connection as to how that comment or that remark in your judgment will impact your decision as to whether guilt has been proven on the requisite standard by the state, which bears the onus to then demonstrate that the accused persons, including my client, accused 1 and 11, are guilty or not. So it's simply on that basis that we say they have failed to demonstrate how that comment will preclude your ladyship from finding properly whether or not guilt has been demonstrated or whether or not they are not guilty. So the submission that we make in conclusion on that point is that those remarks of delay or previous applications that were decided in that fashion, if you view them against the context of the protracted history of the main matter, and in view of the postponement application that the judge was determining, the application that was before you, my lady, those comments were not out of place. And if one is unhappy with those comments, you don't come and re-argue the application and then you clothe it with the dress of a recusal application. You take the matter on appeal, or if you are so advised, you can take the matter on review. But it is impermissible in this jurisdiction to use a recusal application to re-argue a failed postponement application. On the second ground, my lady, there's an allegation that the judge, your ladyship, has been exacting different standards for the parties before the court. This one is similarly weightless and it's premised on the wrong facts. When we pointed out to the applicants, they alleged that we intervened or we opposed an application without filing a notice of intention to oppose on the 19th of January 2026. When we pointed that out, when accused one in his affidavit in answer pointed this out, that there was no application filed, there was no application argued on the 19th of January. Instead of pleading the correct facts in the beginning, the applicants considered that, in fact, they were not referring to the date of the 19th of January. That ground is premised are incorrect. They then went to correct themselves and say, we were referring actually to a matter when Mr. Elago appeared. My lady will recall when I started that I stated that part of the test for recusal is that it must be premised on the correct facts. So on that basis alone, that ground should fail, that it was premised on the incorrect facts. The incorrect facts were pleaded. They were demonstrated to be incorrect. They were inevitably considered in the replying affidavit that they meant a different date. So on the papers, that specific ground also failed simply on the basis of an incorrect, the incorrect facts that were pleaded. Then there is this allegation that this honorable court mischaracterized a preemptive collateral review challenge, that is, and that your ladyship based your incorrect understanding of the review application on pre-2023 pronouncements. Again, my lady, this is again the subject matter of the failed postponement application. The applicants again tried to re-argue this point, and then they clothe it, put on the dress of the recusal. That's not what a recusal application is meant for, my lady. That application has failed, and to bring it again before this court. In any event, my lady, even if they were correct and you had mischaracterized an application that is pending before another judge in this jurisdiction, how does that preclude you from determining a trial and adjudicating the facts when they are brought before you? The fourth ground is one that alleges that your ladyship had predetermined a matter which will become a live issue before it in the main trial. In this ground, it is alleged, my lady, that you expressed a view that you are uncertain as to whether the court has the powers to order the production of a report by the state, a report which you are not sure even exists or is required by that specific provision in our law. How that can amount to a predetermination of an issue is very difficult to even ascertain on the judgment alone. If you read that comment in the or the remark in the judgment carefully, that does not amount to a determination. And even if it was, my lady, a recusal application is not the way to deal with that issue. In fact, you did not determine the issue of the report, nor did the court determine the lawfulness of the investigation. There was no determination made. Once again, not only is this ground premised on incorrect facts, my lady, it still does not demonstrate judicial bias. My lady, the next thing that I'm going to do is to just finalize my submissions by making the following submissions on a general basis. This application, my lady, is in the view of accused 1 and accused 11. It's an abuse of process. It's simply made to delay the commencement of the leading of the state's evidence. The court, my lady, is faced, and not for the first time, with accused persons who, with a fixed and settled intention, they've decided that this trial will only start when they decide it will start, if it starts one day. Now, my lady, this position is apparent from the papers. You will see the, sorry, my lady. You will see from the papers that there's a lot of conclusions made and a lot of arguments that are placed pertaining to the right to a fair trial. But what about the rights of the other accused persons? What about the rights of accused persons, number 1, who has also been detained in custody, who unfortunately, because he's tried with the other accused persons, but they are not twins, my lady. They were not born together, nor are they triplets. There will come a time where accused number 1 will be forced to approach this court to separate, so that the other accused persons can exhaust all the applications they are entitled to on their own time. But that day is not today, my lady. My lady, I'm going to deal briefly with accused 7's affidavit. This one was an interesting affidavit to read, my lady, because in one breath it was titled a supporting affidavit, yet in some paragraphs the accused 7 says he brings the application. So I was utterly confused as to what the position of accused 7 is. Another contradiction that the applicant puts forth in that affidavit is that he brought the application in good faith and without delay, but he at the same time says he's relying on remarks that you made during August of 2025. But then he says, no, I'm not delayed. I'm bringing up this issue now because the facts have now become apparent to me, but I rely on the facts of August 2025. That cannot be. In the same affidavit, he then says, he states that he does not believe that your ladyship has the necessary experience to preside over a matter of such complexity. And I tie that into the submission that was made by the applicants today, that they are relying on this title of a judge. The argument put forth is even, it's basically doesn't make sense. You are saying magistrates have criminal experience, not civil experience. But we are in a criminal trial. This is going to be a criminal trial. Presiding officer, whether it's called a judge, a magistrate, they take an oath. That oath is the one that we should have on our back, on the back of our minds when we look at it. So the submission made by Q7 is that the presiding judge doesn't have the necessary experience to preside over a matter of such complexity. a regional court judge, a regional court magistrate. Just because you are called a judge now, your experience has been brought to zero. Yet at the same time, Q7 states that his position must not be construed to mean that he's questioning your knowledge of the law of procedure. But that's exactly what he's saying. He's saying, I'm of the view that your knowledge of law and procedure is not at the level where it should be to preside. But on this point, my lady, because remember, our law says that a judge should not be overly sensitive when a recusal application is brought. We should look at it objectively, and that's the exercise we're undertaking. On this point, my lady, they would have to fail as well. Because he is in fact questioning your ladyship's competency. But we are not saying judges' competencies should not be questioned. It's an important factor. What is being submitted is that a recusal application is not the process. Let's not abuse and bully female judges when they come before us by repeatedly referring to judges that are no longer amongst the living because they are male. We will not be bullied, not even if the bullying comes in the form of recusal applications. My lady, we submit then that it is reasonable for an accused person to apprehend bias on the part of a presiding judge if such a judge makes a disclosure that he or she knows two of the witnesses on the state's witness list. But if you are saying that the disclosure is inadequate, if you say you only stated, your ladyship, that you know two of the witnesses on the list, that you know them from Oshivarongo, if you are saying that disclosure is inadequate, the correct procedure to follow is to say, my lady, you made a disclosure which is vague. Can we please have details so that we can understand whether or not the extent of your knowledge or affinity of this witness will impact? You don't come and say, because you didn't make a complete disclosure or a full exposition of your knowledge and affinity to the witnesses, you impute a negative inference on that. Inferentially, it will not even, you can't sustain that type of thinking. What we are supposed to request is for this court to indicate that I know these people from church, I know them from kindergarten, or I know them from law school, or we do business together, so that we can determine whether or not that will actually sustain an apprehension of bias. But to bring a recusal application on the basis of a vague disclosure, we submit, my lady, that it is not a reasonable thing to put forth. The witness list, my lady, is in excess of 100 persons. In this jurisdiction, there are lawyers here who know people on that witness list. Some are sisters, some are wives. Our duty is to make a proper disclosure when the time comes and to assess whether or not that disclosure is in fact going to impact our duty to do our job. And is it reasonable to expect in a jurisdiction this small that one will not know a single person? But that's a different question, and it's a different determination that must be made when the right times arise. But it is not really correct to bring it by way of a recusal application. Because your ladyship has not refused, was not asked to say, give more details on how you know one or two people. Are you friends? Did you bride together? Were you watching rugby together? Will you be able to apply your mind as a judicial officer who took an oath without fear or favor? What is not going to be tolerated, my lady, even in criminal matters, is for either litigants or legal practitioners to forum shop. We are not going to allow a situation where when people don't like a judge. It's not permissible. When you don't like a judge, you contrive reasons and you impute a certain state of mind on a judge and say, I need another judge. My learned friend, Mr. Alexander, he conceded the point that if the competency of a person that is appointed as a judge, either in an acting capacity or a permanent capacity, is brought to question or comes into question, the correct approach would be a review application of the decision to appoint that person. That was a good concession to make, my lady. My lady, one of the last issues we wish to raise, it's not an issue for your determination, but it's an issue that we brought to the court's attention because we upon a reading of the opposing or the answering papers by the state, we will observe that it is Mr. Marondedze who deposed to the affidavit, not the PG. My learned friend has placed himself in that position that we were warned against by Angula DJP, as he was then, in the matter of Prosecutor General versus Paulo, where he discouraged legal practitioners from deposing to affidavits on behalf of their clients. And he remarked as follows, I feel obliged to make an observation here that this practice by legal practitioners of filing an affidavit on behalf of a client should be discouraged and desist from. It should only be resorted to in exceptional cases. For instance, where the party to the proceedings is for compelling reasons unable to depose to an affidavit, such reasons must be disclosed in the affidavit deposed to by the legal practitioner. In the instant matter, no explanation has been given why the first respondent could not depose to the affidavit. An affidavit contains evidence. In the event of dispute of facts on affidavits, when they arise, which cannot be resolved by the approach to resolve disputes in motion proceedings, commonly referred to as the Plascon-Evans rules, and the matters have to be referred to oral evidence. In such event, the legal practitioner will become a witness. Such a scenario is undesirable. It is further undesirable for a legal practitioner to align or associate him or herself with her client's cause. It is for those reasons that it is undesirable for a legal practitioner to depose to an affidavit on behalf of a client dealing with factual issues. A legal practitioner cannot astride two horses at the same time, namely be a witness and a legal practitioner subject to ethical rules of conduct. In almost a similar situation, like in Kasu, Masuku J. aptly put it as follows: the conflict of your duty to the court on the one hand and the personal attachment to the matter and the possibility of adverse consequences make it a risky affair. It is akin to riding two horses at the same time. At the end, the rider is likely to fall off both of them and be injured or worse, disfigured in the process. My lady, we've also highlighted that the replying affidavit is in excess of 60 pages. It contains allegations that are made for the first time in that replying affidavit. And today we've seen allegations made about statements by the judiciary, also for the first time here. An applicant must make out a case, my lady, in the founding affidavit and is prohibited from raising new allegations or introducing new evidence in the replying affidavit. New matters are only permitted in the replying affidavit, my lady, to address defenses that are raised by the respondents in their answering affidavits, and in order to obviously bolster the original case made out. My lady, then the question would be, no, we are dealing with unrepresented litigants, or you are dealing with lay litigants. But what does our court say about the rules when it deals with lay litigants? There is somewhat relaxation, but that relaxation does not do away with the rules. The papers cannot be, the founding affidavit cannot be replete with conclusions. There must be facts set out, they must be addressed, and then we leave the arguments for the heads of argument. So for that authority, my lady, on what the obligations of lay litigants are, we, the accused one relies on the decision of Standard Bank Namibia versus Gertze, where the court stated that lay litigants who represent themselves are just as much under an obligation as those that are represented by counsel. And so they cannot, as they please, fail to comply with our rules of practice. My lady, in conclusion, the submission is therefore made that the applicants has simply failed to rebut that very important presumption. There's a presumption built into your oath of office. That presumption is one of impartiality. And to dislodge that presumption, something more than speculation, something more than conclusions, something that is evidence must be brought in order to dislodge such a presumption of impartiality. It's on that basis, my lady, we submit that this application should fail, it should be dismissed. Your ladyship should provide us promptly with a decision so that we can move this matter along, as it pleases the court.
Thank you. Mr. Lutubeze?
As it pleases the court, my lady. The state has also provided comprehensive heads of arguments. I will not regurgitate everything that's stated in the heads of arguments. I'll just deal with the main points, my lady. There was a point in limine which has been raised by the third accused person with regard to the title of the deponent. Rightfully, that point in limine has been abandoned, so I'm not going to deal with that. My lady, on page 4 of the state's heads of arguments, it is titled Accused 1 and 11's point in limine. As I indicated earlier on to the court that the state's heads of arguments were drafted without insight into those of some of the applicants and respondents. I was under the impression that they would raise this point as a point in limine because it was brought up in their affidavit, and subsequently it also came up in their heads of arguments. It is a point that is there in connection with the answering affidavit, which was deposed to by one of the counsels to the matter. My lady, since this matter has been raised here in court, I will briefly touch on it as well. It is a state submission with regard to the answering affidavit deposed to by Mr. Marondeze that he is competent in actual fact to depose to that affidavit. That the contention of the parties in this particular matter, they contend that the parties and not their counsels should depose to the affidavit. And the suggestion before court is that the prosecutor general is the one who should depose to this affidavit as the respondent. For their contention, they've relied on the matter of the prosecutor general versus Polo. And I must point out here that the parties in that particular case were the prosecutor general and Polo. So in that particular case, the prosecutor general was in fact a party to the proceedings. Reference to this case has been made, and where she briefly just highlighted that it has been discouraged that legal practitioners should file affidavits on behalf of their clients. And I want to underline that word client. And it should also be discouraged and desisted from, and that it is further undesirable for legal practitioners to depose to an affidavit on behalf of a client dealing with factual issues. And the court also pointed out that it should only be resorted to in exceptional cases. My lady, although this practice has been discouraged, doing so does not render it unlawful, nor does it render the evidence contained therein inadmissible, provided it still complies with the rules of evidence which are applicable in a certain case. Moreover, my lady, if the court has regard to the Polo judgment, the court has raised that warning in that judgment, but nevertheless, the court in the Polo judgment went to deal with the merits of the matter. And it is important, my lady, to point out what the court said in paragraph 21 of that judgment. This is what the court found: that highly technical objections should not be allowed to undermine or stand in the way of the interests of justice, and to deprive the parties of the opportunity to fully ventilate the real issues between the parties. What is the real issue before court? What is that issue? That issue is the recusal of the court. That is the real issue that we are here for. That is what we are here to determine. So whatever technical objections they may raise, it was also pointed out in that case where the warning was raised that, no, look at the real issues before court. And the court went on to say in paragraph 22 that the object of all litigation is to arrive at the truth and at a fair and expeditious solution. That is very important when the court has to consider what has happened in this case. My lady, I want to point out that when you have to consider the application of civil law in criminal proceedings, we should also be very cautious and very careful, because civil law is a completely distinct field of law compared to criminal law and litigation. These are two completely different sets of laws. The Criminal Procedure Act makes provision for the proceedings, for the procedures which should be followed in criminal processes. Civil law also has its own processes that need to be followed. So just because a particular principle finds application in a civil matter does not mean that it can also be superimposed in a criminal matter. One must be very careful as to how they're going to impose that principle in a criminal matter and the effect of that principle, because if it is not correctly applied, it is going to cause confusion in criminal litigation and applicable law in criminal matters. And in actual fact, that confusion is apparent in what has been raised by counsel for accused one in this case. It's very apparent because what they've alleged before court, and they've relied on these judgments, which were made in the context of civil cases. These POCA applications are also civil in nature. They've relied on these judgments, which stipulate that it's the clients who must depose to affidavits. That's what those judgments stipulate. So if we apply that into a criminal matter, who are the clients? That is the question before court. For the accused person, it's in actual fact very clear. They are the clients of the lawyers who are here representing them. So obviously they must depose to those affidavits themselves. Some of the lawyers just recently joined this matter. They do not know what has been happening, so they are not in a position to depose to that affidavit. Now, who is the client for the state? According to counsel for accused one, it's the prosecutor general. That is the client who must depose to the affidavit. That is wrong in law, my lady. The prosecutor general is not a client in criminal proceedings, not at all. The prosecutor general and us prosecutors who appear before court, where if the court was to consider us in a civil context as a law firm, the PG's office would be one law firm. And the PG would be a lawyer in that law firm along with us. And what has been held in several judgments, there was also a Lepideco judgment, is that not even correspondent counsel is allowed to, is discouraged in effect from deposing to that affidavit. So if those civil judgments are strictly applied to the criminal proceedings, it would mean that the prosecutor general is also prohibited from deposing to that affidavit. So once again, the problem comes in, who's the client who should depose to this affidavit? Ordinarily, it's easy to determine who the client is by simply looking at the parties to the case. It will be who versus who that determines who the client is. Here we have state versus certain accused persons. So certain accused persons are easily identifiable, but who's the client then for the state? State is a very generic term. It's not government of the Republic of Namibia versus who. It's not Minister of Justice versus who. It's not a certain victim of crime versus who. It's simply state. In other jurisdiction, it would say the people of this and this state versus. So it's clear that as prosecutors, we are here for the interests of the public and the state in general. Those in nature affect our clients. So can it be said that we are, in this case, expected then to go to Windhoek and pluck out any random person and tell him to come and depose an affidavit in this case? Can we be expected, seriously, in this matter, to close our eyes and just pick a witness from the witness list to depose to an affidavit in this case? Can we even ask the investigating officer to depose to the affidavit in this case? They can say, all of them, my lady, will simply inform you that, look, I do not have personal knowledge of the facts of that case. We are not able to depose to that affidavit. So the issue then comes, who should depose to that affidavit? Who is that person who has personal knowledge of the facts in that particular case? Who is that person? Is that person identifiable? And yes, in the context of our case, those people are identifiable, my lady. If it's not Mr. Marandeze, then it's I, one or the other. We are the ones who have personal knowledge with regard to what has been happening in this matter. And apart from that, we are the ones with personal knowledge with all these issues which have been raised regarding disclosure and whatnot. There's no other person. And in actual fact, that is one of the exceptions which have been raised in those civil judgments, that the lawyer can depose to an affidavit if that lawyer has personal knowledge of the matters which are alleged in that affidavit. And from the reading of the affidavit of Mr. Marandeze, it's clear he's speaking from personal knowledge. So he's the only person who could have deposed to that affidavit, and myself, of course, either one or the other. There is nothing wrong in law, even if those civil judgments are applied to this case. I've also made reference to the matter of Amadila versus Nghipunya, my lady, in that particular case where the exception also raised that if a party, even if you are a lawyer in the matter, if you have personal knowledge of the case, you can in fact depose to the affidavit. Apart from that, there's been a judgment from Apart from that, there's been a judgment that I referred to. This is the ex parte Shanghala matter, at paragraph 10 of the statement of arguments, where I had also deposed to an affidavit in that particular matter, which was also argued by Mr. Marandeze in that case. And the court in that particular case found that we are entitled to deal with that application, despite one of the parties having deposed to the affidavit. Moreover, my lady, the PG, she cannot be the person to depose of the affidavit. If they consider that the PG is the one who should depose the affidavit, then it's in actual fact a concession that as prosecutors in this matter, we are entitled to depose to the affidavit on the basis that as prosecutors in the matter, she has delegated the powers to us. And by virtue of that delegation, if they consider that the Prosecutor General could have deposed the affidavit, then we would also be entitled to depose that affidavit. I respectfully submit, my lady, that looking at the exceptions that have been raised in some of these cases, the state was justified in deposing that affidavit as its factors that fall within the personal knowledge of the prosecutor. The reason for deposing that affidavit is also contained in the affidavit, where he stated that it's within his personal knowledge, and that is sufficient, my lady. Now, to deal with the real issues which are before court, this is the issue of the court's recusal. My lady, I will not regurgitate that the law has applied. There are several pages of that in the House of Arguments, but I just want to highlight what those legal principles are when it comes to recusal. Because here we are dealing with a reasonable apprehension of bias. This is what is alleged by the applicants. And the court also pointed us that the test is whether, firstly, whether the reasonable, objective, and informed person would, on the correct facts, reasonably apprehend that the judge will not be impartial. That is basically the basis of recusal. Would a reasonably objective, informed person on the correct facts not reasonably apprehend that the judges will not be impartial? So, in actual fact, when the applicants come before this court, they are informing the court that, look, we are reasonable people, and we have reasonable grounds as to why we are appealing, requesting for a recusal. That is what they are informing the court. So are they really reasonable people with reasonable grounds? I submit not, my lady. And to highlight the unreasonableness of the application, I just want to refer the court to my apologies, I just want to get to the... This was the founding affidavit of the third accused person. I've made reference to that, I think, in paragraph 64 of the heads of arguments. And I want to quote what they had said in this application for a postponement. This is what they said. Because this application for a postponement, just a background, it was premised on the review application, which was still pending in another court. So this is what they said in paragraph 34.8. The preemptive collateral review challenge is not before the trial court, and the trial court is not competent, is not the competent court to determine the matter. That is what they said in the application for a postponement. That matter is not before this court. This court is not competent to determine the matter. So it was clear, it was unequivocal. The court must not touch that collateral review application. That is what they say. And rightfully so, because the matter was not before court. So what did the court do? The court did not touch on the collateral review application and the cogency of that application. It did not deal with it. Rightfully so. Now, when the court does not deal with it, what do the applicants do? They come before court and they request for the court's recusal. On what basis do they request for the court's recusal? One of the grounds that they've raised for your recusal is that you are biased because you failed to consider the cogency of the collateral review application, that you failed to ascertain the gist of that collateral review application. So the intellectual fact telling you that, why did you not consider that which we asked you not to consider? Eh? This is akin to a man, my lady, who requests for his spouse to cook porridge. He gets home in the evening, finds porridge, he complains, why porridge every day, just porridge? Why are you cooking porridge? Is that reasonable? Because that is exactly what they've done in this case. They've informed the court, don't deal with this issue. And when the court does not deal with the issue, they allege that the court is biased because the court has not dealt with the issue that they asked the court not to deal with. Is that reasonable? Really? If one looks at those grounds, is that reasonable? That's the first question. Obviously, it's not reasonable. How can you request a person not to deal with something when they don't deal with it, you request for a recusal? And that ground itself is also not a reasonable ground. That is the starting point. I just wanted to highlight the reasonableness of the application. My lady, just to deal with the grounds themselves individually, I'll start with the very first ground, which has been raised by the applicants in this matter. And this can be found at page 12 of the spaces of arguments. Yes. The instance of the ground is that the court predetermined that a deliberate delay tactic exists in the case because she holds the view that applications brought thus far by specific accused persons are without merit. That is the first ground. I'll not repeat in full what the court had said, but I've highlighted the court's ruling in paragraph 14. My lady, I've endeavored to deal with the issues as they are. There's an issue of the delay, which they allege they are not causing. There was the issue of admeritorious application, which they allege they are not causing, and the delay strategy. Now, to start off with the issue of the delay, they've cited the matter of ex parte Shanghala and two others, where the court, I want to quote what the court had said because it's also relevant, I'll just highlight, where the court had said that each party is entitled to take up a point as it sees fit, provided that it is not abusive of court process, whether or not a delay would be occasioned. In this case, an unsuccessful midstream application by its nature causes delay to the main trial, but that is the nature of criminal proceedings. My lady, what is the delay? It's a simple question. What is the delay? I've highlighted there what constitutes a delay. It entails shifting an occurrence to a later time than originally planned. That is a delay. Whatever the reasons are, it can be valid reasons, there can be invalid reasons, but has the matter been delayed? If it did not start as scheduled, then there is a delay in that matter. And in this particular case, my lady, this matter was set down for trial since 2 October 2023. There have been several trial dates which have been set down, and the matter has not commenced. Why has the matter not commenced? That is the first question. And the answer is quite simple. There are several applications which have been brought, which have consequently delayed the application. And that is what the court had said in the matter that was cited, that you can move these applications. They may or they may not delay the proceedings, but it's the consequence of moving the application. They can delay those proceedings. And the court said the unsuccessful midstream applications by its nature causes a delay. And it is no secret, as Mr. Shanghala has said, that it is statistically impossible of the losses that we've endured with reference to the application. So we know that they've been unsuccessful, and according to that judgment, there have been delays. My lady, I've also made reference to several judgments which were delivered by Judge Nengo in this particular case, where in actual fact found that the accused persons have caused delays in this matter. The first is the State versus Gustavo, 27 others. At paragraph 18 of the State's case of arguments, just at the very end of paragraph 24 there, where he had highlighted that to be remembered is that of 10 individuals facing charges, 3 have been ready to proceed with trial. Their interest in the finalization of the case must be taken into account and balanced against the position of their colleagues who want a long delay to the continuation of the trial. That was the judge's finding, that the colleagues, some of the colleagues here, they wanted that long delay in this matter. And the court went on to say, and in actual fact, my lady, the applicants before court have in actual fact acknowledged that they are causing delays in this case. And that acknowledgement can also be found in the matter of Shanghala versus the State, which is highlighted at paragraph 19, where the court had made reference to their affidavit at paragraph 13, where they, the applicants themselves, said that once separated, they were applying for a separation of trial. They said that once separated, the trial of respondents 2 to 18 can then proceed unhindered and without delay, whilst the trial of the applicants can proceed with a full realization of the right to legal representation in whatever permutation the Honorable Court wishes to grant the applicants. So it is quite clear that the applicants were in actual fact aware that they are causing delays in this matter, as they had said in one of their prior affidavits, that they want to separate so that the trial of the others can proceed without delay, because they know that theirs is going to be delayed by a number of applications which are being moved. So they acknowledged that, yes, we are causing a delay in this matter. It's acknowledged. It's there. That acknowledgement was there before this court even joined the matter. So what they're informing this court is that, yes, they themselves can acknowledge they are causing the delay, but the moment the court also acknowledges they are causing a delay, all of a sudden it's bias. Is that being reasonable? Not at all. No reasonable person will have that apprehension that the court is biased simply for stating the facts as they are, in which the accused persons or the applicants have acknowledged in this matter. Moreover, I see, I'll not really touch on the issue of the state causing a delay, because the judgment which they cited acknowledged at the end that the state was ready to proceed with trial, so there's no need to deal with that. Now, with regard to the unmeritorious applications, as they allege that was said by the court, I've cited several judgments there in paragraph 28 which were dealt with and dismissed. My lady, the applications that have been brought before this court have neither been withdrawn, struck from their roll, or were they determined on points in limine. These cases, my lady, were heard on the merits. And any dismissal of these cases, my lady, was consequently on the merits, even if that was not particularly said by the court that, yes, on the merits, I'm dismissing this. It was on the merits because the matters were determined on the merits. These were not withdrawn or struck from the roll applications. And in any event, as highlighted in paragraph 25, 29, my apologies, that matter of Shanghala versus the state, the court had also acknowledged his, the accused trade also referred to that provision, that for the reasons I have given in the preceding paragraph, I am satisfied that the Vanya application has no merit, and stands to be dismissed. So it is clear that the court would listen to the merits of the application, and if it was dismissed, it had no merit. Now, with regard to the allegation of the tactical delay strategy, it has been highlighted in paragraph 33 of the state sense of argument that there was no definitive finding by this court that the natural fact was a tactical delay strategy. The court was merely expressing its difficulty in not finding to a certain extent that there may be such a delay strategy. My lady, in any event, even if there was such a finding that there is a tactical delay strategy, the court would have been entitled to make that finding because there is, in fact, a tactical delay strategy which has been embarked on by the applicants in this matter. In the matter of Van Wyk versus the state, is cited in paragraph 35 of the state sense of argument. The court has said that I do not think that the accused person's stance in relation to legal representation should be construed as a stratagem to delay the trial indefinitely. Now, they want to argue that this was the finding by the court, that there is no delay strategy. But the court purposefully and deliberately, my lady, inserted the word there indefinitely. And that changed the whole meaning of the word. So the court has found that there is no strategy to indefinitely delay the matter, but there is a strategy, a deliberate strategy, to delay it for a fixed period of time. So that was the court's finding, and it's very clear. I don't know how this provision can be misinterpreted, but that's what it says. And in actual fact, that interpretation is the correct interpretation which has been proffered by the state. Because barely 6 months after the court's finding in that particular case, which has been misinterpreted by the applicants, the court in Shanghala versus the state had this to say. I've cited the page numbers and everything. I'll not regurgitate those, my lady. The court said, has earlier pointed out, these applications have the effect of designedly or incidentally or further delaying the continuation of the main criminal trial. That is why the court said, by design or incidental, okay, it appears maybe the court was not too sure, but okay, that is what the court had said there. But at paragraph 23, the court says, there are several reasons in my view that militate against the success of the venue application. I am of the view that it is not a bona fide, but intended to delay the hearing and finalization of the separation application. The court at paragraph 40 held that I am not convinced that the appointment challenge is bona fide, or that it is not a ruse to buy more time to so the applicants may, regardless of how long it takes, secure legal representation of their choice. So here, it's unequivocal. There was a strategy to deliberately delay this matter. That was the finding of the court. The court even took it a step further than the presiding judge. The court touched on the applicants' bona fides. This court has not done so, but the court in that particular matter did so and found that no, they are not acting in good faith in these applications. That was the finding of the court. So evidently, there's nothing wrong, even if this court had said that there's a deliberate delay strategy. That has been the finding of the court in the same criminal matter, not in a different case, in the same criminal matter. These judgments have not been appealed against, they have not been set aside, they stand. So really, can any reasonable person who's acquainted with the correct facts, who's acquainted with all these judgments, can any reasonable person really be of the view that this court hold the view of a reasonable apprehension of bias when there have been judgments to the effect that there's the deliberate delay strategy by the applicants and the application is not bona fide? Certainly not, my lady. So really, there is no reasonable, properly informed person who's acquainted with the facts, including these prior rulings, my lady, in which Justice Chinengo acknowledged the deliberate delay tactic by the accused person. No person could reasonably apprehend that the presiding judge in this matter is biased. The second ground which has been raised on page 24 of the state sense of arguments is that the court exacts unfair different standards from the parties before court, and this ground is a reason based in the manner in which the applications were dealt with, wherein they filed their notices and their affidavits. The state had not done so in this particular case. This is where this allegation of bias stems from. It is the contention that the state was obliged to file a notice of intention to oppose along with an answering affidavit. I respectfully submit, my lady, that that is not the case, because any applications in terms of Section 168 of the Criminal Procedure Act can be moved viva voce or opposed viva voce. There's no need for notices to be filed. These are criminal proceedings. They remain in the realm of criminal proceedings. These are not civil proceedings where the strict rules of civil law must be applied. I've made reference to the matter of State versus Thomas. A similar issue arose in that case where the lawyer filed their notice, and it was accompanied by an affidavit. And the prosecutor merely wanted to address the court from the bar without filing any notices, without filing any affidavits. And the lawyer was of the view that, no, that is not proper. They should file their notices and their opposing papers. And this is what the court has to say. First, the court made reference to the matter of State versus Strovisky, where the court had highlighted in that Strovisky matter where civil motion proceedings had been instituted in criminal proceedings. The court said that I am unimpressed by the fact that the application was brought by way of notice of motion, a recognized civil procedure. That is one thing. At paragraph 5, the court pointed out that it was pointed out to counsel that the application could be argued summarily and that there was no need to adopt the procedure proposed by him. This was clearly a matter falling squarely in criminal proceedings. That is what the court said. These are not civil proceedings, they are criminal proceedings. There's no need to file notices, affidavits, there's no need to that. And there's case law to that effect by this honorable court. I've referred to the matter of State versus Kennedy as well, where motion proceedings were utilized, although there was a notice of intention to oppose, which was filed in that particular case. There was no answering affidavit filed, but the matter was also handled on that basis, despite that procedural, civil procedural mishap that did not take place in there. Of significance, if they just asked the accused 7, he could have informed them that it's not the correct procedure. Because in the matter of Nghipunya versus the state, in that particular case, there was also an issue which was brought regarding the manner of moving applications in terms of Section 60. In that matter, in the magistrate's court, when we were having the bail application, it was argued by their lawyer that once a notice of motion and funding affidavit had been served on the state was obliged to file a notice to oppose and an answering affidavit. Now, the Nghipunya judgment, my lady, this firmly rejected that contention by the lawyer as it was raised in this particular case. And the court said that with deference to counsel for the appellant, this approach submitted to the court a quo is, in our considered view, clearly wrong. So the court did not accept the view that just simply because a notice has been filed, an affidavit has been filed, a recognized criminal civil process, that then the state must follow suit. And in fact, that is what is said in the summary of that Nghipunya judgment, where the court highlighted that in criminal proceedings, this is in terms of Section 60, the use of affidavits, reference to the civil process, is permissible, but the state is not compelled to follow suit. So from the cases that are available, the state is not compelled. Just because they've filed or chose a civil process to institute through this court, the state is not compelled to follow that process. That is what the rulings say. And based on these rulings, my lady, can one really say that there can be a reasonable perception of bias when the court is merely following the law as it is in the country? No, there's no reasonable perception of bias. It's the law as it is. And the court was correct in hearing the parties, even in the absence of filing opposing papers, as long as the application was opposed orally. That was sufficient. My lady, there are a lot of other issues. I see some of these issues have not been touched on by the applicants in the arguments before court. As I indicated, I stand by the state's heads of arguments. So whatever is said in the heads of arguments, even if I do not say it in court, that stands as a point by the state. So I just want to move on with this allegation that, and it was mentioned that they were denied an opportunity to reply. My lady, that is not the case. The third accused person in this case, my lady, has indicated in the haste of arguments. He's a prominent lawyer. I think everyone in Namibia knows Mr. Shanghala. He's a very prominent lawyer. And he has served as chairperson of the Law Reform Commission and held office as Minister of Justice and as the Attorney General. Those are some of the top offices that can be held by any person with legal qualification in Namibia. A lot of lawyers aspire to be in those offices. So he really knows the law from his time at the Law Reform and Development Commission, as Minister of Justice, and as Attorney General. Apart from that, he's now a very experienced litigator. He's been litigating for 6 years. Not a lot of lawyers in Namibia can say that I'm in court almost monthly litigating. No, he has vast experience. He's been dealing with the application time and again. And it's obvious from all these judgments that have been delivered that there are so many applications that he dealt with. So he knows the procedures which have to be followed in those applications. If he does not want to reply to a certain issue, he has nothing to say. It's as simple as that. Because whenever Mr. Shanghala wants to say something, my lady, not even this court is going to stop him. He will say what it is that needs to be said. So there is no merit in this allegation that he did not have an opportunity to say what he needed to say. We listen to him here for days, the whole day, from morning to evening. We can be here just listening to Mr. Shanghala. So really, there's nothing on this ground that has been raised. Finally, not finally, but on the third ground, I've already touched on that ground, my lady, with regards to the allegation that the court did not deal with the gist of the preemptive collateral review. So that was the fifth ground in actual fact that I had touched on. And I just want to highlight, I think, one more thing on that particular ground. They had made reference to the Supreme Court judgment of Shanghala versus State versus Shanghala and others at paragraph 67 of the State Service of Arguments, page 35. Whereas they allege that the citation of this matter was reproduced as reflects the dismissive views on the merits in relation to the ACC exercising its powers. But my lady, this is clearly not justified. Because, and I will quote so that I do not lose the court's findings. Because the court's finding in this particular case was clear in the Gustavo matter, in the State versus Gustavo matter by the Honorable Presiding Judge. It said that it is clear from the above Supreme Court that the Supreme Court was of the opinion that the legality of the manner in which the evidence was obtained against the accused will, as a matter of course, affects its admissibility, and that is therefore a matter of adjudication by the criminal trial court. So evidently, the reason for referring to this judgment, my lady, is to highlight that some of these issues that are being raised, my lady, these are issues to be dealt with by this court. And this was in relation to the postponement, in relation to the issues which were raised in that collateral review application. Now, on the fourth ground that has been raised is that the court had predetermined the matter that will become live in the trial when it considered the application made in terms of Section 82. Once again, my lady, so as not to lose what the court had said in our case, the presiding judge, in this case in Shanghala versus Prosecutor General, in paragraph 97, had said that nowhere in the section is any mention made of a report, and thus it is unclear, I've highlighted that word, that it is unclear to which report the applicants are referring to. The court cannot order disclosure of a report requested in terms of Section 83 of POCA if the provision relied on does not make provision for the compilation of the report. Now, this question whether or not the report should be disclosed, this was an issue before the court. It was not an issue which has been prejudged. It's an issue before the court. And the court merely looked at the provision of the section, and the court, rightfully so, found that the section does not make provision for that report. And that was correct, just based on what the reading of the section itself. If they read it differently, if they claim it makes provision of that report, they can bring an interpretation, because their argument is that the court has already interpreted the section. but which is not the case. There's no interpretation of this section. The court merely just referred to the section. If they deem it appropriate for the section to be interpreted, they can still move an application before this court. The court has not closed its mind to the issue. The court can still adjudicate on that issue if they bring cogent evidence as required. And I've also made reference to several judgments in there, my lady, that, well, the correct course, like paragraph 7 of State versus Basson, that the correct course, if they are not happy with the court's finding, it is a ground for appeal. It's not a ground for alleging bias. It's purely a ground of appeal, and that is what they should have done in this particular case. My lady, there have been an issue which has also been raised by the parties in this case regarding the allocation of this matter to the court. As the parties rightfully conceded, it's not a matter for determination of this court. It's not a recusal application before this court. It has nothing to do with this court. They know Judge Nengo. They brought the application for his recusal in a different forum. And it is in nature of fact surprising that accused 3 now he made a submission to the effect that he wishes that Chinengo was here. But they applied for his recusal. What is he talking about? They did not want him in this case. Now all of a sudden he wants the judge to be here. Really. My lady, all these other allegations that the choices the judges make are influenced by the ODSS whose approval they seek. What influence is there? He does not highlight to the court. Is the court influenced to go in a certain direction? Maybe he must tell us that the court is being influenced to acquit. I don't know. He does not say. So these are all just speculative. There's really nothing more to these allegations, my lady. It's just speculation. And this court is properly equipped to in nature of fact deal with this matter. Because I saw from the attachments that the court has been a presiding officer for at least about 25 years. 25 years sitting on the bench dealing with issues. Really, my lady, that's vast experience. And I can assure this court that that 25 years is in actual fact more than some of the judges' experience on the bench. So how can one claim that, no, you are not properly equipped to deal with the matter when you've been dealing with these matters for about 25 years? A criminal case in the regional court, a criminal case in the magistrate's court is not different from a criminal case in the high court. The rules of evidence are the same. There's nothing different. So this court is more than properly equipped to deal with this matter. Although there's no merit in that application, my lady, I will not really dwell on that application. Now, as for accused 7 and 25 supporting affidavit, I've read the affidavit, I've read the heads of arguments, my lady, and one thing I noticed is that they are devoid of any case law to support their contention. So they're just filled with speculation and feelings. There's no case law, there's no legal basis for what they allege, nothing at all. They just allege, no, we feel the judge must recuse yourself because you know 2 of the witnesses. Oh, no, I feel maybe you have some interest in this and that. It's just feelings. The court is not here to deal with feelings. The court is here to deal with the law. What does the law say? That is what I expected to hear from counsel. That, look, my lady, this is the law. This judgment says you must recuse yourself. You know 2 of these witnesses, you must not sit on that bench. That is what I expected to hear. But there's nothing there. But fortunately for them, my lady, they need not worry. The state has cited the law in this case. The judgments are there. I will start by referring to the matter of the Tunga versus Kava Ongelwa. Apologies if my pronunciation is not correct. That is a paragraph 90. In instance, the allegations there by one of the parties is that he previously was a friend to the judge. He even produced pictures of them together some years back. Those were basically the allegations against him, and it was of the view that the judge should not preside on that matter. But nevertheless, the court in paragraph 22 pointed out that the defendant's allegation is that the friendship existed in exile. Not only is that no basis for recusal, but the implied premise that anyone who had been a friend of a judge in the past or shared association with the judge cannot sit in judgment over them only needs to be put to be rejected, absent any allegation why such friendship or association assumed the character which renders the judge unsuited to be a judge in the matter. And that is what happened in this case. Those allegations are not there. It's interesting to note, my lady, that the court was quite frank with the parties in this case. And that is what is expected by the court. The court came out, the court informed us, I believe it was even on the first date, that I know two of the witnesses in this matter, but I am not friends with them. That's what the court said. Now, when that information was conveyed to us, and the court in actual fact inquired, does anyone have an issue for you to sit on this matter? I think the echo was the same all over, that no one had an issue with you sitting on that matter, despite that frank disclosure by the court. Now, I see counsel for the accused person complains, and the accused person complains in his application that that is not sufficient disclosure. You should have told us more. My lady, the court gave an opportunity on that date to inquire further. If they wanted to know more about how you know those witnesses, they should have inquired further. That is what was required from them. But they chose not to do so. They chose to fold their hands, and they decided, well, we don't need a further inquiry, but we'll just apply for the judge's recusal based on what was said. So to them, what the court said was more than sufficient to apply for your recusal without having further information. And we can see from the papers that they filed that the absence of this further information has caused them to speculate about your relationship with those people, how long you've stayed in Ochuarongo, and whether you have business interests. They simply don't know. They're just speculating. And that is what we are not here for speculation. They were at least supposed to provide cogent facts that this witness is close to you in this and that manner. So on that basis, you will not be impartial. That's what they should have done. But they do not do so. So they are satisfied that just by knowing a witness, that is more than sufficient for the court to recuse itself. My lady, if that is really true, one thing that we know for sure, as the court sits here today, the court knows the parties who are sitting here, the lawyers. The court knows the accused persons. It's not a lie. The court knows the accused persons. The court knows people in the gallery. So if one accepts their contention that just simply by knowing a person you should recuse yourself, it means that this court cannot preside over any matter because you know the people. So knowing people, my lady, is not sufficient basis. Is not a sufficient basis for recusal. There should be something more to that. And I want to highlight I've made reference there to the matter of State versus Lamb. I will not regurgitate that, but it's also a matter where a magistrate had previously worked with a police officer, and that police officer's son had appeared in court. The police officer had approached the magistrate, and she had recused herself, and the court had set aside that recusal. And it pointed out that there is absolutely nothing that occurred between the magistrate and the gentleman that suggests that because of the encounter, the magistrate is no longer free to exercise the judicial powers impartially. Again, same thing here. There's nothing to suggest that just because the court knows two of the two witnesses, that this court cannot exercise its judicial powers impartially. They needed more evidence, but there's nothing that has been presented before this court. The most important case on that point of knowing the witnesses is the case of Silas Fikameni Shilongo versus the state. This is a Supreme Court judgment. This judgment is binding on our courts. Now, basically in this particular case, my lady, the magistrate has been appointed to head the Anti-Corruption Commission, but he still has some cases which he needed to finalize. And when dealing with one of those cases, one of the witnesses was his subordinate to the Anti-Corruption Commission, and issues were now raised that, well, are you going to be impartial, considering that the person who's testifying before you is your subordinate at the institution? And this is what the court had to say at paragraph 14 of the Supreme Court. and it applies also to judges, that magistrates, being the first of the judiciary in lower courts, preside over cases in which their subordinates are witnesses, namely maintenance cases, missing records, etc. They preside over cases in which police officers they may have known for many years in their jurisdictions are witnesses. They may castigate them or criticize them in one case and then commend them in another. It does not follow that in subsequent trials, the magistrate should recuse herself where the same person is a witness. Without more, the mere fact that a subordinate of a magistrate is a witness at a trial is not sufficient to infer reasonable apprehension of bias. And it's exactly what is happening in this case. The court can preside over cases in which it knows the witnesses, in fact, even have known the witnesses over many years. So even if this court has known those two witnesses over many years, the court, according to the Supreme Court, this court is still entitled to deal with that matter. Because there's nothing more that has been put before court apart from the fact that the court knows those two witnesses. That is all. But that is not a sufficient ground for recusal. My lady, I think in conclusion, I just want to submit that a reasonable, objective, and informed person would, on the correct facts of this matter, not reasonably apprehend that this honorable court is biased, my lady. And I therefore submit that the application for recusal of the honorable presiding judge should be dismissed, my lady. My lady, that is it for the state submissions, unless there's something else that the court wants me to address it on.
No, thank you. Mr. Shanghala, your reply?
It was a very entertaining submission done by the state. It's very good to see Mr. Kuzilwandle and his client, Mr. Marondedze, are in sync. Thank you for the commendation, Mr. Kuzilwandle. You should have gone far further to thank me for the industry which I put into those institutions for what they are today. But nonetheless, you have acknowledged a couple of things, and then you have also gone to say things which are simply just not true. And Judge, I want to start on that. It is not true that I ever, in my life, ever brought a recusal application against anyone. You are the first one. In my own person. As AG, we had to bring one against Theo Frank. But I'm saying I never brought an application for recusal. You will not find that in the record anywhere. And if you find it, Judge, then seriously, throw away those papers. They are not telling you the truth. I never brought an application for a recusal of a judge in this matter. If it is said by anybody, it is a lie. It is a lie. In fact, when I tried to join the leave to appeal of the recusal that was brought by accused one, the state shut us out by saying that you never participated, you can't participate now. That is what happened. So the very person opposing me for bringing an application for recusal is the first one to have ever brought a recusal application in this matter. That's accused one. When they did that, I did not say you are delaying us. What's good for the goose is good for the gander. Secondly, this is important, Judge.
Yes, it's also on the facts, not on the law.
Excuse me, Judge?
You are addressing me on facts, not on the law.
Yes, I just thought that you were being misled. One of the duties of the officers
I'm
of the
fully
court-
aware that you never brought a
Thank you.
recusal
Thank you very
application.
much, Judge. Oh, I feel much better. Let me go to Thomas. The case of Thomas was referred here by Mr. Lutubezi. I'll start with the state and then get to Ms. Gebhardt later. that was on page 26 to page 27 of their heads. I'd like to refer you there too. They referred to the State versus Thomas, in which it refers to the Stravitsky matter, which Justice O'Lynn was hearing. Incidentally, Judge, I attended the ruling, the giving of the judgment of this matter. In this matter, what was happening was a request was made, an application was brought on formal notice of motion for the postponement, for the matter to, under section 160, what is it? 168. Right? And then the court quoted from another Stravitsky judgment. And this is what they said. This is at page 27. Moreover, where the application is entirely based on the court's earlier ruling when refusing an application for postponement of proceedings, that's when you don't need to formalize those requirements. You will remember, Judge, that I said to you that if you read section 168 of the Criminal Procedure Act, nowhere does it require me to bring an application. You remember, I said this to you. And then you said, we must bring an application. And I said, fine, we'll bring an application. And then we brought an application. My fear is that since you've taken the view that applications are a waste of time and a delay tactic, that now every application I bring is painted in that brush. But let me read 168 for you. (168) says, sorry, I just lost it a bit here. I'm there right now. Yes. Court may adjourn proceedings to any date. 168. A court before which criminal proceedings are pending may from time to time during such proceedings, if the court deems it fit and necessary, adjourn the proceedings to any date, etc., and it ends. Why do I read it to you? I also want to use it to dispose of the argument of Ms. Selma Gebhardt, where she says that we are re-arguing the adjournment. According to this, from time to time, what does that mean? It means now, tomorrow, again. It doesn't matter. That's the whole point. And it says so clearly, on the law, it says so clearly. That application may be considered from time to time, whether it's a formal application or whether it's just one who stands up. So this is not authority for the view that once civil proceedings are adopted, that the state is not bound by them. That's not the position taken in Thomas. In Thomas, it is to say that dealing with this postponement, you didn't need proper formal procedures here. But in Kasu, we have a situation where the court said, when proceedings, a format has been adopted, those are the rules of the game. They must apply to all. That is the point. That is the point. So Stravitsky is being read out of context by the prosecutor. Then he quotes Shanghala versus the state, where the judge says designedly. That judgment of 18 November 2024. That judgment, if you read the judgment, you will find that it deals with two issues. It deals with the 149 and 168. And as we put it to the court, we were compelled by Justice Mwatelulo to bring that application. And he says there, a delay in the separation, that application, the separation of trial application, not the entire trial of CC 06-2021. It was that particular one. So he wanted to dispose of the matter without dealing with this issue. And we told him we had to bring it here because we were instructed to bring it here. And then he hit us with the non-joinder. and then we had to go back. That is the context. So if we are applying the law, let's apply it in the context in which it was created. And he even granted us costs, by the way. Now, delay apparently will be caused by applications. That's what Justice Shinengo says. It's in the nature of the game that delays will be caused. And by the way, these delays are being caused at the instance of the state. The state has been delaying us here, opposing Section 26 of the POCA applications for Mr. Esau. He succeeded, they appeal it, they lose in the Supreme Court. Was that not a delay? These are delays. They are part, the nature of the game is that issues must be ventilated. Now, and they say they've been ready to proceed. Were they ready to proceed when disclosure was not done? Were they ready to proceed when the pretrial was not done? Were they ready to proceed in the face of people not legally represented? Is that what they're saying? They have a duty under Article 5 to ensure that those rights are protected as well. So when they keep pontificating and repeating it, it doesn't make it true or right for that matter. A very good example was used here of the porridge parable. Pap. Oshifima. Now, the point is missed by Kuzilwandle, if I may call my young brother Kuzilwandle. He misses the point. And this is the point. The point is, when we brought the application for the postponement of proceedings pendente lite, the preemptive collateral review application, it is because that application deals with issues that will become live here, and it deals with issues relating to the administrative actions and exercise of public authority, which produces consequences such as a docket and evidence. We're not reviewing the evidence. You see, it's a review. How do you review the evidence, by the way? I thought to review the things that... So when you then went to characterize it that way, and I'm saying it's pre-2023. Last week we heard Justice Frank succumb to the high arguments and falsehoods of his own argument. You see, this is what he said. He said, no. A, B, C, D, and then you can do what... That's what he said in the judgment. He created a whole panoply of a scenario in abstract. We came with fact and we said, this is what the section says. And then Parliament went to amend it. And then he says, oh, but you see, Justice Schreiner is actually correct. Where there's a parliamentary exposition, you have to take that one. It has an impact. Now you want to proceed while we are saying, wait. And we are saying, no, but Judge, I think you are biased. That is the whole crux of the issue. We are saying you come into this case, you come, and what is being characterized by Ms. Selma Gebhard as what we base the application on is not actually correct. It's one of the reasons. It's not just what you wrote in your judgment, Judge. I quoted you, I provided you a copy, I annexed your exchange with Mr. Marondeze and then me. On the first day you came here, you came with that view. There's a delay. There's a delay. I must start. Now I'm saying, don't start, wait. There are issues being determined there. They are relevant. They may even dispose of this matter. And here I have non-joinder. I can't raise them here. I have to do that. That's what Chinengo said here later. He said, you have non-joinder issues. You may have to deal with issues here or another forum, but let's deal with them after the plea taking. I take it, but then you still just want to go ahead. That's where I come with the Deutsche Bahn. So that is the crux of the issue. Now, as for the issue of the PG and Mr. Marondedze, I will leave that to the judge, the state, and Ms. Gebhardt to deal with. I'm not going to get involved. But I do want to start, Judge, with I think it's important. It's not a point of law, but I think it's important to say. The mansplaining was not necessary. Did you get me, Judge? The mansplaining was not necessary. I have been an advocate for women in the legal profession. I've promoted them, I've sent them for education, I've encouraged them, I help them, I still pray for them. I cannot be told to be, you know, it's not right, Judge. I think that was a low blow. But it's okay, I can take it, but I'm just worried that it hasn't infected your mind, that this is a person whom I need to treat now with more heavy-handedness because this person is against women. I understand the extramural activities of the representative of accused one with women in law, and I applaud it, but it wasn't necessary here. That's not what I was doing. Judge, on the point where you said, and I want to deal with my last point that goes to paragraph 3 of the notice of motion first to dispose of it, where when we were interacting and you raised that issue with Mr. Alexander as well, you said, but isn't that an issue for review? I'm saying, fine and well, there are many remedies or avenues available in a matter, and maybe that one may be the appropriate one. I'm not conceding it because I don't need to. It wasn't the basis upon which I bring the application. My point is, but it's not an issue. That was the only reason why I was raising that issue. Now, I want to deal with the issue of how do you formulate the apprehension of bias. It's a legal issue. It's as much a legal issue as it is a factual issue. So what I've said is, on the 4th of August, you said this. I engaged you. I believed I had disabused you of that position. Lo and behold, here comes the judgment. You say this and you go further. You say all these applications. Now, I'm saying these two facts, I deduce from them and conclude that I have reason to believe that you have an apprehension of bias. So when it is said that my papers are full of conclusions, how else do I bring about the apprehension? I state the facts, and then from the facts, I draw an informed conclusion. All right? So that puts to bed that issue. Now, Judge, I fully agree there shouldn't be forum shopping. I fully agree that we should deal with the issue before a judge, and a judge can only recuse themselves when there is a consideration of the correct facts. I agree with that principle. Which are the incorrect facts here? That's not what is being said. The principle is being stated, but you're not telling me these are the incorrect facts you are relying on. They repeat my facts, and then they say the principle. But you're not saying those are the incorrect facts. Then, in paragraph 58 of our founding affidavit, Judge, there we state already the issue of the different standards. You see, the question is this. Why did the state file heads of argument? Why did they file a notice of intention to oppose the notice of the leave of appeal that has been filed by accused 8? Why did they file an answering affidavit? If they're not bound by it, it's a concession. And then, how did they end up? How did accused 1's legal representative end up in the judgment of 21 January if they were not then invited into the application when they had not even applied for an application made an application to intervene? The matter was argued on the 1st of December. Accused 1 was represented. Nothing. We come on the 19th, they make representations. In the judgment of the 21st, they feature prominently. Those are the facts, and they're indisputable. That's what I say in paragraph 58. So I don't understand how I'm taking things out of context. In fact, the argument contrary to that is what is called sophistry. Mr. Kuzulwandle will then know from my many jobs that he cited that I can teach him this word, sophistry. That is sophistry. Now, Judge, I just want to make it clear. It is being said that you don't have a duty to recuse yourself and you shouldn't be insulted, you shouldn't be attacked. I did not insult you, I did not attack you. Not at all. In fact, never mind. Unfortunately, the business of a recusal application is not a very nice one. And the business of litigation is not a very easy one. It's gruesome. If you give, you must also be able to take. If you call me that I'm without merit and I'm whatever, then I must also, and I'm saying, I think you are biased. It's what it is. So the reason why judges shouldn't recuse themselves is based on the presumption of regularity. But if I impugn that regularity and I say that, no, we can no longer presume regularity, that is the basis why recusals are done. And judges shouldn't be fickle about these applications. And I hope you're not, Judge, because really I'm just trying to obtain a fair trial. That's all I want. Competent, impartial, independent court. That is what I'm promised in Article 12. Clear, nothing else. Now, I want to leave you again with the quotation from Muzi Sikakane.
In reply to which part of the state's submission?
This is the one where they say there's no merit.
But it's something that is already in your...
Yes, I just want to refer you to it so that you can see where it is. When they say that it has no merit, I'm saying, but it has merit. And I'm saying that it goes beyond just, it says there, you see, it says, it's on paragraph 6.7 of my heads. Having addressed that, the last thing I need to say, Judge, is that I had brought an application for the separation of trials. The state opposed it. Accused one, fronted by me, joined in that application. If it is the case that people are legally represented and they feel that they are ready to proceed to trial, I think it's just important that you allow them to bring an application to be separated. Because I'm still struggling. I'm waiting for the Supreme Court judgment. The hearing was on the 26th of February. If that court determines that the POCA falls away, then I'm able to marshal my estate and to participate in the economy, even though I'm in prison, with my intellect, to be able to earn an income that is not going to be attached and can pay for my legal fees. So I too have the right. So Mr. Lutubezi was saying that apparently the judge said, no, the rights of others, they are ready. I also have a right. I think it's a premium right to be represented. And I just want to realize that right. And that's the last thing I want to leave with you, is that we will commence a trial and I'm not represented. Not because I want to be not represented. I want to be represented. Because I'll have a fool for a lawyer if I'm my own lawyer. But I want to be in a position to do that. You don't want that. You just want to start because apparently it's been delayed. And because all my applications are of no value. And this is the problem I have. And on those bases, I have not only made out a case for the recusal, but also for the relief that I seek in paragraph 3. And it's not based on new facts that I'm bringing. You see, you can try and ignore it and whatever it is. But the fact is, if permanent secretaries are now becoming acting judges as well, there's a scarcity. You don't have judges. We don't have judges in the country. People who understand civil law. And why this case? Because this case will be beset with many interlocutories. And they are of a civil nature. They're not provided in the Criminal Procedure Act. And that's the point. And the judiciary itself is saying, surely this statement must have been done by the one, or with the knowledge of the one who sets the norms and standards of the judiciary constitutionally. That's the Chief Justice. Can't come out of his office and it doesn't say so, and he doesn't know. He says, but the magistrates just don't have, not always provided suitable for appointments to the civil service. This is the problem we have. So it's not my say, so it's the Chief Justice. And with that, Judge, I thank you as it pleases the court. Please remember the issue that I had raised earlier.
About what, sir?
I raised 2 issues in the beginning. Which one was it? Issue was Numa, and then I raised 2 issues at the beginning. Oh yes, the filing I had sorted. I attended to that was the issue of the 2 filings that we did. You remember the 2 filings? So I've dealt with the issue of the officer in charge, that it remains a pregnant situation, that we may be coming to court in the civil stream, because here there's non-joinder on the issue of our rights, if that happens. So please, it's not us delaying. It's really, we just need our rights to be protected. Thank you, Judge.
Thank you. Mr. Alexander, any reply?
In short, my lady. My lady, the test, as was discussed or was mentioned during the submissions by the different parties, is simply that whether a reasonable, objective, and informed person would, on the correct facts, reasonably apprehend that the judge has not or will not bring an impartial mind to bear on the adjudication of the case. Now, it is really as simple as that. It is if one has to look at the test that this court needs to apply, and the facts on the basis of which the application is brought, then simply that is the issue that this court has to deal with. I'm saying this because so many statements were made on behalf of the state and on behalf of accused number 1. Let this be a court of law, not a court of social activism. Now, lastly, my colleague for the state is missing the point. It is not an issue that the court dismissed an application for a postponement. The issue is the expression by the court that it is a tactical delay. The fact that today's application caused a delay to the starting of the trial, that is not contended. It's a fact. But whether it is a tactical delay, from the position where you are sitting in, my lady, that is not a fact. It's a conclusion, if not a perception that the court is allowed to bear upon yourself when looking at the person bringing the application. But it becomes effect when we are saying the court has said this. And on the basis of what the court has said, objectively, as a reasonable, objective and informed person, I'm allowed, or I may reasonably apprehend that going forward, whenever I come back to this court with the same application or with an application or an objection, the same perception will bear upon the presiding officer when dealing with my objection or my application. So that is the issue. So the problem is the word tactical, because tactical means that when I'm bringing this application, I'm not intending to achieve a recusal, but I'm intending actually to achieve something more than a recusal, carefully planned to achieve a delay instead of what I'm alleging in the papers I'm asking. So that is the difference. This is the court, please.
Thank you. I know it's late, Mr. Nghipunya. You lodged an application for leave to appeal the postponement ruling.
That is correct, Madam.
Can you provide me with proof of service thereon, or proof of lodging filing at the registrar's office?
As in today, my lady.
No, when the application for leave to appeal, or the notice,
Yes,
because I received nothing.
we did file everything, my lady, with. Let me just look at my document.
Maybe, Mr. Nghipunya, I see you are a bit at a loss now there in your file. I do not want to place you under pressure. So take your time and look for it.
As it may please the court, my lady.
In the meanwhile, I suggest that we remand the case until the 23rd of March. That's today, 2 weeks from now, for the ruling on the recusal application. Mr. Nghipunya, if you in the meantime come across the proof of filing, please provide it to my assistant, and then we will take your leave to appeal further, also then on the 23rd of March.
I think
Sorry, Mr. Lutabes, I see Mr. Samherji. You might not have noticed he was standing before you, Mr. Samherji.
Your Ladyship, is just in respect of the application that we had already alerted Your Ladyship that we would make. Your Ladyship is well aware that accused 10 was granted bail in a judgment on 12th of December 2023, and part of the conditions that were attached to his bail were that he is not allowed to leave the district and area of Rehoboth without written permission from the investigating officer.
District of Rehoboth.
Yes, Your Lordship, amongst other conditions, but that is the pertinent one with regard to this application. Accused 10 has since received an offer of employment as a shop supervisor at Baines Laundromat. The letter of offer of employment signed by him has already been disclosed to the state. Beg leave to hand up this copy to the court.
Mr. Lutube, is there any objection to that condition being relaxed?
There's no objection, my lady. He can be allowed to leave Rehoboth for purposes of employment for Monday to Friday, my lady.
Will he work on weekends as well?
My lady, just wanted to correct my learned colleague. It works on weekends also as well, as is evident from the letter. It also says Saturday and some Sundays. So basically, we are making an application for the relaxation of 3.4 of the conditions, so that to indicate that he should be allowed to come to Windhoek for work purposes.
It's in order, my lady.
Yes, unless there's anything else. Case in remanded until the 23rd of March, 23rd of the 3rd month, 10 o'clock, for ruling on the recusal application. Mr. Nghipunya will sort out your application for leave to appeal also on that date. We will sort out your leave for, or your application for leave to appeal also on that date.
God bless his name.
In respect of accused number 10, your bail condition that you are not to leave the district of Rehoboth is cancelled. Your bail then extended until the 23rd. Accused 1 through to 9 in custody until the 23rd of March at the Windhoek Correctional Facility. Court adjourns.